Hello and welcome to ICTICT418 Contribute to Copyright Ethics Privacy in the IT Environment. In this presentation we will be going over what characteristics identify the Copyright Act, where it came from, how it applies to the ICT environment. So let's kick off with copyright. What is it? It is the property that is created when a person creates an item such as a poem or a piece of art. The skill, creative skill, and the labour involved in creating that piece of work is protected under copyright. Now, there are other laws that cover motion pictures and music. So, with the convention born in Switzerland in 1886, the treaty was signed, and out of this treaty we basically have the governing principles of copyright. And at the time of my presentation in 2019, there was 117 signatories out of 195 countries in the world. So that's almost all of the world signing to protect copyright around the world. So it's pretty good. Now, China signed the treaty in 92 and signed the trade-related aspects of intellectual property rights in 2001. Now that's important for us oldies because they were a holdout for quite a number of years, causing quite a lot of problems with people taking copyrighted material and mass producing it in China. So that's now changed. Under the current laws and standards relating to intellectual property and copyright here in Australia, it is enforceable under Australian law. Now, the Copyright Act was defined and amended in 1968, and it applies to all states and territories throughout Australia. So how do you get it? Well, just by the act of creation. The Copyright Act is applied to the creative works. You do not have to apply for it. It is an automatically protected act. So just be aware, copyright doesn't cover ideas in names, titles and slogans of businesses, that sort of information. That comes under other forms of protection. So what happens if you copy software or download music or photographs and without the permission of the copyright owner? You are actually causing a breach of the Copyright Act, which means you're breaking the law and can be charged as under the Criminal Law Act. So what we can do is look it up in the Communications.gov.au website, what we do copyright, and it explains what they act and how it applies with copyright within Australia, and it has links out to like IP Australia and things like that on this website as well. So this will be our starting point for research for our assignments. Now, as with every good government act, they say you shall not do something, but they give themselves a out so that they can do it. So under the Copyright Act, the government has a license that allows them to use copyrighted material for official purposes, and you can look that up within the policy listings, government use of copyright material, off that communications.gov.au website. It's always good. So, implications of being caught with unauthorized material is that you basically are breaking the law, and most people think of piracy as it's okay to do. So, taking images, taking video, downloading music, all that sort of stuff is protected under the Copyright Act and is enforceable by law. So there are pretty impressive fines. So fines up to $99,000 for 5 years imprisonment. That's quite a nasty thing. Now, under the Act, penalties for corporations can go up to $585,000, and individuals within the corporations can be fined up to $117,000, and both of those individuals can face 5 years imprisonment. Now, I found John Gibbs' channel on YouTube, and they've got 6 short videos on copyright. They're about a minute and a half each, and just very concise, nice little watch. And he also has a series of videos on trademarks and patents, which just give you a different perspective on what we are doing in this material. So what's protected under the Act? Text material, so literary works such as journals, novels, screenplays, that sort of thing. Now, under that, the Act was amended so that computer programs come under literary works as well, and compilations such as combining various literary works together. Artistic works, so photographs, plans, sculptures, cartoons, all that come under there. Screenplays, music. The music itself is copyrighted, and it's separate from the lyrics and the recording. Film video is protected separately, as I said earlier. The scripts are under literary works, so broadcasts and that come under the separate sections, but a lot of it is under copyright as for TV and radio, but films come under a different set. So in 1984, the amendments of the Act was where they added computer programs in, so the code is creative and is protected under copyright. And under the Act, according to this, it's author plus 50 years for software. Now, normally, a lot of, if you read in the government website and that, they say the life of the author plus 70 for most of the others. So this only applies to the software. So there is Australian federal, state and territory, and there's industry standards and ICT business standards. Now, just to be which ones apply and which ones don't, well, basically federal and state and regulations that are basically enacted by governments are mandatory for you to comply with. codes of practice, national standards and industry standards are all voluntary. They don't have the act of law supporting them. They're just best practice and can be used in cases to say, well, the standard is this, why didn't you comply with the standard? So there is that argument. Now, common law, legalist, forget it, I can't pronounce it tonight. So have a look at the laws that apply through the various websites. If you just do copyright or common law or Vic law, you'll get lots of links to various websites where you can look up what is applicable to each state and what is covered under federal law. So intellectual property is where we look at protecting property rights that are a bit more than just copyright. So under intellectual property, we get creators and inventors get exclusive economics rights to what they've created, and these are not necessarily physical. They're things that you think of, you invent. So, making a design of a house is intellectual property. A new machine, plant breeders, all sorts of things come under there. Now, these intellectual properties are protected under the Patents Act in 1990, and the patent gives the inventor, the owner, life of the patent, which is 20 years, which allows them to do what they wish with that invention, but they can increment that up and down of periods of 8 years. So if they want to release it to open, they can apply for a decrease or increase their patent in groups of 8 years. Trademarks, which is words, phrases, shapes, logos, this sort of thing, are granted protection under the Trademarks Act of 1995, and your registration of that logo or whatever it is under the trademark is for 10 years with renewables possible. Okay, so what does it apply to IT? Well, everything in copyright, intellectual property, discrimination, fair trading, all of that applies to us, as well as every other industry. So all the standard privacy laws, anti-discrimination, fair trading, all of this applies to IT as well as other industries. But we have specific laws and standards that apply to us with regard to the electronic side of communications, which is anti-spam, e-business, telecommunications, and digital agenda amendments of the copyright law that specifically apply to our industry. Industry standards can be developed by government or international, national or state industry bodies. They are a guideline on how to conduct operations and provide us what's acceptable or not acceptable as far as a professional standard is concerned. They are not legally binding, but they can be used to support legal argument if your copyright or intellectual property is challenged in the court of law. Policies are like standards. they are not legally binding, but they, once again, can support a legal argument if you have breached a government or industry policy that has been widely recognised as supported. So if you're not meeting those things, you've got to justify why you're not when you're challenged in court under anything. Now, copyright protection, as I said early on, is automatically granted. So one of the scams that's gone around over the years is a letter demanding a registration fee for copyright protection, and it is just that, it's a scam. So it is applied straight as copyright, straight away as you've created the item. What you need to apply for are patents, trademarks, that sort of thing. Now, you don't actually have to put a copyright notice, but a lot of people put some form of notice that state that the works, especially under literary works, it's protected under the Copyright Act and you need to contact the owner, It is recommended that you put some form of dating and naming on your works. This is why artists and all that sign and date their work, because that tells them under the Act who's the copyright owner and which year or date that they created the works. So if there's a dispute over who created it first, having that date or a journal, sketches, all that sort of thing help you to protect your ownership of copyright. And this is basically what this slide is about, having to record some history on the creation process so that if somebody claims it's their work, not yours, you've got some documentation to back up the claim. What's the difference between an author and a copyright owner? Well, the author is the person that originally created the works. The copyright owner can be a person or a company which owns the rights to the work in question. So a lot of employees, for example, under their contracts with their employers, automatically sign over the copyright ownership of any works they create while in their employment contract. So just be aware of that. So the owner is normally the person that created it, but it can be anybody that is sold or transferred the ownership. Okay, so there's rules governing those. So all of this can be varied by agreement, and normally when we're talking about a commission works, the person commissioning the work is required to tell the creative what they're going to use that piece of work for, because the artist can legally restrain the use of the work outside of that commissioned. So for photographs, paintings and that sort of thing, there's quite a interesting debate about who can do what to what, and basically it comes down to the contract between the two parties. Remember that the creative person is the owner of the copyright, so if you're commissioning work such as a photographer, they are under a contract to give you certain pieces they take, not everything that they take about the subject matter. So additional material from my learning there and research across the various websites will be required. The Wikipedia listing of Copyright Law of Australia, Copyright Law in Australia, a short guide, protection of computer programs are all articles that you should read. And as I said earlier, John Gibbs' channel on YouTube is a very good short videos on the various elements of copyright, trademarks and patents, well worth a watch for a different perspective on what we just covered. Now, up on our class links, you'll have a PDF of this slideshow. All those links are active in the PDF, so you can just click on the link in the PDF and it'll take you to those items. There should be a copy of those 3 articles in extra learning resources in My Learning, and this will cover the basis of the 2 assignments that you need to complete based off copyright. There's a little bit of researching on government websites and that to do, and some videos that are listed in the assignment that you need to watch and answer specific questions on. So I'll leave you to it, and happy reading. I know it's a very dry subject, but we have to have a basic understanding of copyright and how it applies to our industry and what's protected and how it's protected. Okay, thank you for tuning in, and I will see you on the next video. Thank you.